Here's a segment from a recent Gun Talk radio episode. You can listen to all the Gun Talk radio podcasts however you tune in, or check out guntalk.com for more. We have had several things happen in the courts in the last week. It seems like every week I say, hey, several things have happened, and they're happening that quickly. The biggest one, I think, was a decision by a federal judge in the Eastern District of Virginia. That's U.S. District Judge Robert Payne. He ruled that the federal law that says 18, 19, and 20-year-olds cannot buy handguns from a gun store, that law is unconstitutional. In other words, the federal government cannot prohibit people who are 18, 19, and 20-year-olds from buying handguns. We have thought this for a long time. And we said, this makes no sense. If you can vote at 18, if you have other rights that are guaranteed under the Constitution at 18, you can't require people to wait 3 years to exercise their constitutional rights. The judge said if the court were to exclude 18 to 21-year-olds from the Second Amendment's protection, it would impose limitations on the Second Amendment that do not exist from other constitutional guarantees. Something to understand a lot of this stuff is that the Supreme Court has ruled that deprivation of your constitutional rights for even a day, that is irreparable harm. Losing your rights for even a day is irreparable harm. Now, I would imagine this is going to be appealed. You've got to assume that to be the case. But this is a federal judge ruling that it is unconstitutional to prohibit people who are 18, 19, and 20 years old from buying handguns. I mean, come on. You can drive a tank. You can serve in the military. You can carry a fully automatic firearm when you're in the service. But when you get back out, now you can't go buy a handgun. Makes no sense on the face of it. And clearly, it is unconstitutional. A lot of us have thought that for a long time. There's something else going on, as long as I'm on the subject of courts. And I did not go to law school. In fact, those who saw me in college said I didn't actually go to college at all. There may be some of that too. But I've been reading an awful lot of briefs and cases and decisions. And in Illinois, you have two parallel things going on, but they're now linked. Illinois passed a horrible gun ban, banning semi-automatic firearms and standard capacity magazines. Try to boil that down. Two judges said, yeah, that's okay. We're not going to stop that. One judge, Judge McLean, I believe it was, he said, no, we're going to put a stop to that. You can't enforce that. We're going to put a stay on that. And we're going to have a temporary restraining order. And that was appealed. The Seventh Circuit said, no, we're going to take that back off. So now the law is back in effect. That was appealed, and by whom is interesting. That's a side note. I'll get to that in a second. To the Supreme Court, U.S. Supreme Court. And the way it works is that there is a judge, a justice in the Supreme Court who oversees certain circuits. And it just so happens in the Seventh Circuit, the justice who oversees that is Amy Coney Barrett. Justice Barrett looked at that and then ordered the city of Naperville, where one lawsuit is involved, because the city of Naperville has its own ban on semi-automatic firearms, and ordered the state of Illinois, which just has its new ban on semi-automatic firearms, to submit comments or briefs to her to say, why should I not stop this right now? Now, I am told by people who know these things, it would be highly unusual the Supreme Court to step in at this point in the process and put a stay on this, to enjoin the enforcement of these gun bans. Because usually the Supreme Court says, hey, you guys all work it out in the lower courts, and when you're all done with all the appeals and everything else, and then you want to come talk to us about it, we'll talk to you about that. We'll take a look at it and see if we want to take it. So it's very unusual that they would want to do this. And they may not. They may decide, yeah, we're not going to get involved at this point. But there's also, I think, a little better than usual chance that Justice Barrett will actually put a stay back in on this, because that would be preserving the status quo where citizens can buy regular semi-automatic firearms and regular magazines, which they've always been able to do, and stop the imposition of this ban until it all gets worked out. Again, if you lose your rights for a day, that is irreparable harm. So I'm hoping that she comes back and says, yeah, we're not going to deprive people of their rights while you guys are arguing this out in court. We shall see. Now, the tag to all of this, before I hit the break here, is this. This is a great example of how Bruen has changed the landscape in a way that you may not have thought of. In the past, you have heard me talk about the Gun Owners of America and the National Association for Gun Rights, and not in glowing terms, because I wasn't a fan of what they were doing in legislatures. But I think it is the National Association for Gun Rights that has brought this case in Naperville, and they're doing good things. So what's happened here is that you have these kind of new-ish groups to the legal side of things getting very involved, because they figured out that's where the action is. That's where the landscape is changed, and that's where they can actually do some things. So very interesting what's going on here. And, it's like, okay, welcome to the party, and I'm glad you're here. And, I don't care that you just got here now. If you're doing good work, good on you.